Okay, thank you very much everybody for coming. My name is Nicola Dunbar. I am the Senior Manager of the Research Service, and I'd like to welcome you to this session in the Parliamentary Library to discuss protest law. I'd like to begin by acknowledging the traditional custodians of the lands on which we're meeting today, the Gadigal people of the Eora Nation, and pay my respects to their elders past, present, and to all Aboriginal people here today. Given the subject matter of today's session, I would also like to acknowledge the long and proud history of protests by Aboriginal and Torres Strait Islander people in Australia, including here in New South Wales. On the 150th anniversary of white settlement in 1938, there was a day of mourning and protest in Sydney. There were freedom rides in the 1960s, and there have been marches over Aboriginal deaths in custody in recent decades. Protest activity in the law has received renewed attention recently, and this prompted the Research Service to update a paper that was written in 2015 to provide a current overview of this complex issue. On your seats is a quick look at the paper by my colleagues Tom Gotsis and Rowena Johns, who will be joining us up on the stage later. And it provides a comprehensive coverage of all key legislation that relates to protest in New South Wales and in other jurisdictions, as well as an update on legal and procedural issues and key cases, including the challenge in the Supreme Court from last year. Today, what we're going to do is build on the paper and take a closer look at protest and the law. We're very pleased to have Simon Rice with us here today to explore these issues. Simon is Emeritus Professor of Law at the University of Sydney and an experienced legal practitioner and senior legal academic. His appointments are too many to name, but in summary, he has taught, researched and advised on matters of discrimination, human rights, legal ethics and access to justice, including as a legal advisor to the Federal Parliamentary Joint Committee on Human Rights. There's plenty of seats down the front if you want to come and sit down here. Plenty of seats. Please come forward. It's great to have you. Thanks for joining us. The way we're going to structure the session today is that Simon will speak first, and then we'll have a conversation between Simon and the authors, Tom and Rowena, who will join him up the front here, and then we'll be open to questions from the audience. So without further ado, and I'm just thinking if more people want to come and sit down rather than standing up the back, please feel free. Now is a good moment. You know, that moment in the play where they say you can't enter before now, but now would be good. And I'll hand over to Simon to start the session off.
It's all right. As a university teacher, I'm well used to people walking in and walking out while I'm speaking. So, good afternoon. This is a huge topic, and so my remarks are intended to introduce you to the report, which is as large as the topic warrants. And to raise a few things for you to think about, but it's certainly not a lecture on protest law. You really have that in the report. The promotional email that you got for this event tells you that I successfully sued the New South Wales Police for false imprisonment, assault and battery. That's after they withdrew the charge against me. And all that arose from my being arrested on the sidelines of a student protest in 2020. The arrest and the aftermath turned out to be sort of involuntary field research on my part, and it led me to investigate the law on protest in much more detail than I had done before, and when I was teaching protest as a law reform tactic in my course law reform. That experience, I hasten to say, doesn't give me any special standing to be up here and talk to you about protest law, although the journalists loved the headline, Professor of Protest Law gets arrested in protest, and it did make me a sort of a go-to person, so I had to brush up a bit. Really, I'm here because I do have expertise that informs my commentary on the law and debates concerning rights, common law rights, statutory rights, and international human rights, and that's what protest engages. Rowena and Tom do an excellent job to outline not only the law but its rationale. The in brief summary that is on your chair gives you the answers to principal questions. But as Tom and Rowena say in their introduction, this is a really complex and contested area of law. And their very extensive paper is intended to support your better understanding of that. And so I commend the entire paper to you. Although it's complex and contested, there are some simple starting points. And one of them is one of my favourite quotes, and I use this a lot to explain the law to people. It's sourced to many different places, but it's simply this. At the common law, everybody is free to do anything subject only to the provisions of the law. That is, you can do what you like unless there's a law against it, which is pretty fundamental when you think about it, but it needs to be spelled out for people. One such thing that you can do as you like unless there's a law against it is protest. The so-called right to protest is the right to do and say what you like, as far as the law allows. So the law of protest in New South Wales is actually about the laws against protests. That's where we find it's what circumscribes your otherwise freedom, which is really the law about protest. It's the laws that limit or against it. I think it's nicely illustrated by the fact that that law in New South Wales, the law about protest, is in the negatively titled Summary Offences Act, whereas, as Tom and Rowena point out, in Queensland, the relevant law is a positive statement. It's called the Peaceful Assembly Act, 1992. Underneath those contrasting approaches, one a limiting one and one a promoting one, if you like, they're much the same. Both Queensland and New South Wales do the same thing, but in a minute it'll become clear why I'm focusing on Queensland as the paper does. So both operate so as to provide a system that authorises protests or assemblies, so as to protect participants from liability or culpability for certain offences that might occur. You get a degree of protection if your protest is authorised in both jurisdictions. But a significant difference, and for me in these remarks, the most significant difference between the two, is the basis on which authorisation is given in New South Wales and Queensland. And this is really something that I'd like New South Wales to reflect on, is how authorisation, or the limits on protest, might be approached differently. Obviously, a protest isn't going to be authorised if it involves breaking the law beyond the protection that the authorisation gives. I'll come back to that. So I'll come back to the illegalities that can be engaged in when you're protesting. But within the bounds of lawfulness, a protest is authorised in New South Wales under the Summary Offences Act and in Queensland under the Peaceful Assembly Act. So let's look at the contrast. Under the New South Wales Act and the Summary Offences Act, it's not specified the basis for which an authorisation will be given. There are no statutory considerations. It's up to the police and the courts to decide for themselves whether the protest should be authorised, and unsurprisingly, over the years, they've developed considerations of their own. You might think that it's preferable for the legislature to decide circumstances for permitting or limiting the exercise of such a fundamental democratic right as assembly or expression, but in its wisdom to date, the legislature has not specified that and left it to the courts and the police. The paper quotes my Sydney Law School colleague Jeff Gordon, pointing out that really the Act leaves it to the judges to formulate their own criteria for exercising a statutory function and to bring to that process their own values. There's a degree of authority and precedent, but it can be quite a subjective exercise. In an inclusive list, the paper summarises the considerations that the police and courts in New South Wales have developed. They look at the purpose and the message of the Assembly, the prospects of the Assembly causing harm, violence or invasion of privacy, and the willingness of organisers to consider alternatives, different route, different date, different times, other methods. Now they're sensible enough criteria, but they're not fixed. And there's a lot of room for judgment in that, particularly when it looks at the purpose and message of the Assembly and judgments that are made about that. So a consequence of this very loose, broad, non-prescriptive approach in New South Wales is that it's never certain whether the police, the courts and the proposed protesters all anticipate the same considerations, let alone approach them in the same way. And another consequence, as Rowena and Tom point out, is that courts have exercised their discretion on the basis of their assessment of the value of the cause that's the subject of the proposed assembly. And again, I'll ask you to reflect on whether that kind of subjectivity is desirable when the legislature is authorising the exercise of a democratic right, subject to that sort of subjective assessment. In Queensland, it's different. We still have the system of authorisation, and the authorisation is going to permit or deny a protest. But there the legislature has taken the lead, not by prescribing in advance and in the abstract, but by prescribing a reasoning process, saying to the courts and the police, how do you work this out? And that reasoning process treats the right to assembly and to expression. Right to protest is effectively those two rights, assembly and expression. It treats them as human rights, not as mere common law rights, and sets out what a human rights lawyer recognises as a reasonable limits test, having regard to the objects of the Act. So Queensland says to the police and the courts, you are dealing with limiting human rights, therefore you will consider that in the way that established jurisprudence on human rights considers limitations. So in New South Wales, where the question is simply, should the Assembly be authorised? In Queensland, the question is, and it's a long question, how can we ensure the exercise of the right to participate in public assemblies, subject only to such restrictions as are necessary or reasonable in a democratic society in the interests of public safety, public order, and the protection of the rights and freedom of other persons? Now, in a longer talk and in a class, I can break that down for you. It's a reasoning process where you ask yourself a series of questions, which once you get used to it, you can do quite quickly. Most of the world, think of all of Europe, does this all the time. Human rights reasoning is how they decide limiting and accommodating people's competing rights. But that's the formula. How can we ensure the exercise of the right to participate in public assemblies, subject only to such restrictions as are necessary and reasonable in a democratic society, in the interests of public safety, public order, and the protection of the rights and freedoms of other persons? Now, if that test was applied in New South Wales, and I haven't done this, the empirical work, I think you'd get very different results in the authorisation of protests. Just to illustrate how that works, and perhaps to reassure you if you're concerned that that may, I don't know, be too loose, open floodgates, too confusing, the paper draws your attention to a 2020 Queensland case of the Attorney General and Shree, Kershaw and Harland. And there the court asked the question I've just set out for you of a protest that would have blocked the Story Bridge in Brisbane in the middle of the day. They proposed sitting down in the middle of Story Bridge for an indefinite time from midday on a work day. Now, you'd like to think that authorisation would not be granted for that, and it wasn't. The court decided that this form of assembly in this location on this day imposes a significant burden upon the rights of other citizens and upon the public more generally. And I deliberately emphasise some words. The court was making a decision in the moment. It was saying this form of assembly in this location on this day is a significant burden. On another day, it may present quite differently, but you go through that reasoning process to get there. So the research paper singles out Queensland because of that positive recognition of the protest rights and the reasoning process, standing in contrast to the non-positive and absence of reasoning process in the New South Wales legislation. But, as well, Queensland is itself a human rights jurisdiction. Even without the Public Assemblies Act, you'd be going through the same process. I'd say this just to clarify it when you read the paper. The paper emphasises Victoria and ACT as human rights jurisdictions quite appropriately, but because it's identified the Public Assemblies Act in Queensland, it doesn't talk then about the human rights dimension of Queensland. But don't be confused. Queensland is the same as ACT and Victoria as a human rights jurisdiction. So in those three jurisdictions, that human rights analysis I put to you will happen in all three jurisdictions. It just happens to be replicated as well in Queensland and the Public Assemblies Act. Now, I said before that a protest isn't going to be authorised if it intends breaking the law. If the intention is to break the law, it won't be authorised. So it follows from that the laws that criminalise forms of assembly and expression are themselves protest limiting laws. And it happens that in New South Wales we have a lot of them. So they're listed in Table 2 of the report across 6 legislative instruments. These are the offences, and I'm omitting reference to causing damage because I'm not suggesting that you can turn up and propose to deliberately cause damage and be authorised to protest. But take the word damage out, and New South Wales prohibits assembly and expression in these circumstances. Unlawful assembly, disrupt major facility, disrupt or obstruct major bridges, tunnels and roads, climb on a structure, climb on a bridge, pedestrian obstructing a traffic, willfully prevent free passage, obstruct a railway and trespass. Authorisation, specifically under the Act, excuses 2 of those. So of those 9, 2 are excused by authorisation. You're excused the offence of participating in a public assembly if your protest is authorised, and you're excused the offence of obstructing in a public place, which is how the protests are allowed to march down Macquarie Street. But that means that even when authorised, a protest in New South Wales cannot disrupt a major facility, disrupt or obstruct major bridges, tunnels or roads, climb on a structure, climb on a bridge, obstruct a railway or trespass. Now I heard myself say that, and you might think, oh, I'm criticising that or expressing surprise that it's so extensive. I do think it's extensive, but it's a matter for Parliament to reflect on. Is that how far we want to go in restricting protest? All those things, presumptively, not according to a reasoning process in Queensland, but presumptively necessary to limit protest. One of these, disrupting a major facility, is about to be subject to statutory review by the Attorney General, Section 214A, I think. Now, I don't know the process that's proposed for that statutory review. They can be fairly straightforward administrative exercises, but I'd respectfully suggest that the review of a law that limits public protest by criminalising even entry and climbing would appropriately engage in public consultation. Public consultation on laws that limit protest, I think, is apt because this is contested territory that lies at the heart of our democracy. The questions that arise are who is allowed to speak, when and how? What lines does Parliament draw in saying who's allowed to speak, when and how? What limits does Parliament impose, as I said before, presumptively, locking in legislation what you simply cannot do regardless of any circumstances? In whose interests are the limits being imposed and at what cost? You know, I've never heard anyone say, I'm opposed to protest, full stop. What I do hear is people saying, I'm not opposed to protest, but, and it's the but, which is a perfectly legitimate point to get to, but it's where do you go after that? It's the but that I think the review of 214A and more generally a reflection on the protest laws in New South Wales needs to think about. In a human rights jurisdiction, the terms of the but that qualifies protest are arrived at by that reasonable limits analysis. And in New South Wales, we don't have that mechanism. That mechanism weighs up competing considerations and seeks the least rights-limiting approach. Instead, we have to express, debate and accommodate, or more formally, argue in front of a judge, the whole range of competing values that bring people to the issue. And I think the review of 214A could consider bringing some rigour to the issue by using the reasonable limits reasoning and seeing where that gets you to on thinking about protest. Essentially, it's a matter of values. I mean, this is contested space, and upstairs is a very contested space, and it is a competition of values. But even within that competition, there's room, I think, for anybody approaching the question of protest to ask themselves that but question. How far are we prepared to go? At what cost? Perhaps the most significant contribution that I want to make in that talk, and I think the paper does it, is inviting you to think about what's at stake as a human right. These are rights to assembly and right to expression. That's still a fairly novel way of thinking about things in New South Wales. It's how do I do this? Increasingly less novel, decreasingly novel around Australia. As we have 3 jurisdictions that now adopt a human rights approach. The federal government has its current inquiry due to report at the end of this month on a human rights jurisdiction. So it's not out of the question that we would think like that. And guess what? 20 years before they had a Human Rights Act, 30 years before they had a Human Rights Act, Queensland passed the Public Assemblies Act. So Tom Rowena and I are now going to talk about the report, but that's my little introduction, which I hope prompts you to think reflectively on where we are in New South Wales about protest. Shall we have a chat?
Thank you, Simon. That was great.
Professor Rice, thank you so much for your generous and insightful remarks.
Tom, can't hear that.
Can we hear now? Great. Yeah. Thank you so much for your generous and insightful remarks, Professor Rice. I'll ask a couple of questions before Rowena does as well. From your perspective, are we in a different environment now when it comes to protests? By that I mean, are laws becoming more punitive and are protests becoming more disruptive?
On the last, are they more disruptive? Look, it's not peculiar to protest law. I think social phenomena generally. Old people like me, we still have short memories. Young people don't have those memories. You want violent protests? You go back a generation, 2 generations, 3. We have a long history of pretty robust, let's say robust, protest. No, I don't. My study of them, and I can recite them, tells you that we've had a long history of pretty vigorous protesting. So no, I don't think it's worse now than before. It's always available for capital to be made of them on whichever side of politics. This is a political question. I don't mean to be political in anything I say. I seriously don't. So when I say make political capital, either side will do that. If it's binary, all sides will do that. So no, I don't think it's any harsher. You asked, but that was the last question. The earlier one
Was, are the laws becoming more?
Are they more punitive? I don't need to focus on New South Wales here. I think we all know that the Western democratic world is becoming a little more punitive. A shift to autocracy is noticeable. And New South Wales is not the only place to have ratcheted up limitations on protest. That ratcheting up is moderated where it happens in a human rights jurisdiction where there are constraints on how far you can ratchet it up. And jurisdictions without those human rights constraints are freer to keep going. So some of the more recent amendments in New South Wales, as I said, may not have survived or in their current form a human rights analysis. But yes, we have harsher restrictions on protest now than we did before.
In your talk, you discussed issues relating to the Summary Offences Act. How effective do you think the Summary Offences Act is in its current form in supporting the right to protest?
Support. Certainly it's not. Remember what I said, the right to protest. Does the Summary Offences Act support that? What it's there to do is to authorise it. It's a really cumbersome process to go through. The timing is difficult. The forms to fill in are difficult. It's not a smooth process to get authorisation. It supports the right to protest in that, and I give it its due, it protects protesters from a degree of criminal culpability. It allows them to march on streets and obstruct. So to that extent, yes, it enables protest. It could do it in a more efficient way, but the point I made is it doesn't facilitate protest to the extent that it leaves the decision of authorising to be at worst capricious and at best a sort of values-based subjective decision. So it could operate better in doing what it does. Yeah.
You spoke in your talk.
You spoke in your talk quite a lot about the human rights approach. Do you think human rights legislation in other jurisdictions is effective in facilitating the right to protest? And are there still limits? And not only, I guess, limits in the way you were talking about limits before, but also the human rights states, if we could call them Queensland or Victoria, still have offences or introduce particular laws that some may argue are punitive?
I don't think it's especially helpful for me, and I'm reflecting on, to make this all about human rights. New South Wales, I'm not suggesting we're going to get there very soon. So we need to talk. I need to talk about what matters in New South Wales, what's feasible. That said, you asked the question about other states. One of the odd things about the way Australia jurisdictions have gone about human rights is that they reserve a parliamentary override. Parliamentarians and the Attorney General does stand up in Parliament and say, I declare that this piece of legislation that I am introducing is contrary to human rights. But I'm entitled to do that, and it remains a valid law. So we don't invalidate laws for non-violating human rights. I advised the Parliamentary Committee for some time on the human rights dimensions of federal laws, and it didn't matter that I said that the law was fundamentally contrary to human rights. It's still valid. So in a way, it doesn't matter. It's a thinking process. It's a mentality. The really significant thing, I'll try not to spend time on this, is the next level down. Where does it matter? It actually matters. So coming back to Victoria and Queensland and the ACT, human rights thinking and practice in administration is where it really matters, not so much in the legislation. So when police in Victoria consider whether to authorise a protest, they have to do so through a human rights framework. They have to weigh up those competing considerations. That's where it matters. And the second point is it remains illegal. It remains unlawful to damage property and so on. So there are still the lawfulness constraints. It's just that in New South Wales, we have gone further than other jurisdictions in anticipating all the possible illegalities and legislating them beforehand. So that case I read out, they limit protest in Queensland when they weigh things up, but they also allow a lot of protest when they weigh things up.
Also, would you say there are necessary or desirable reforms in relation to protests in New South Wales that if you had input into it, you would recommend?
I think we could look again at the processes under the Summary Offences Act. If we like the fact that protests are going to be authorised, then we could make the authorisation process more straightforward, and we could think about, as you've heard me say, prescribing some of the criteria for doing that rather than leaving it open, because it creates huge uncertainty in the minds of the police and the protesters about whether a protest is going to go ahead. So fix the timing, fix the criteria, and basically you could keep going as we're going if you like. Yeah.
When protest law is passed and enacted in a very short time frame, as happened with the Roads and Crimes Legislation Amendment Act in 2022, what does that mean for parliamentary scrutiny?
Well, it sort of answers itself, doesn't it? And again, my experience in the federal sphere was we'd be working really, really hard to get a scrutiny report through on a bill as quickly as possible, only to find that it passed last night and we're still on the draft. That's a design of the process. And without being too pointed, that really depends on how seriously the institution takes the process, that it has a scrutiny exercise that doesn't actually bite. So, yeah, clearly that's problematic. On the other hand, scrutiny reports, and New South Wales reports do this as well, I use them. Scrutiny reports do stand as a really useful documented exercise in analysis for future reference, but that's really not their primary purpose. They're there to make a difference to legislation.
And lastly, you mentioned the upcoming statutory review of Section 214A and using the reasonable limits approach. Could you further expand on that and what it would bring to New South Wales?
In the time available, Tom, I suppose I'd say the invitation is to look at not just 214A, but the list of offences that constrain the exercise of expression and assembly rights, those rights, and step back and say, do we actually know all the circumstances in which these rights are going to be exercised such that we can anticipate them, legislate against them and ban them, and keep adding to the list? And so how did the amendment work last week? We already had roads and tunnels, and then we had to add bridges, and we could probably add other things. Do we want to do it like that? Or do we want to step back a bit and say, as the occasion arises, there is a way of thinking about this, and rather than just adding to a long, long list, 214A, B, C, D, let's weigh up what the competing considerations are and prescribe a process for that decision to be made in the moment. And I think the committee, a review, could do that. Yeah, it could do that. It gives me a chance just to mention one thing which I didn't, which goes right back to my being arrested. The one thing that did give me cause to reflect on, and I think comes up in this question, is so much of this is in the hands of the police. This is a matter of police discretion. This is what the police decide to do in the moment, whether or not they move in or not. And I mean it physically, like they'll be standing there and they will decide, let's go or let's not go. And I've seen the body-worn video footage of the protest I was at, and there was a moment when it happened. Now, that's their decision. Once they decide to move, then there's a decision about what they do, what they charge with, what they pursue. So the discussion here, we've got to come down a level to where it really matters. And I think the direction that the police are given ultimately by legislation is really, really important, how that flows down. And if the direction is, here are the things that you will not let happen, well, that's what they're going to do. If the direction is make an assessment of what's going on, then I think they have a very different approach.
Okay, thank you, Simon and Tom and Rowena. We'll now open up to questions from the floor. We've got about 10 minutes. Are there questions that anybody has? Yeah, Mark.
Talking to the microphone. Hi, fantastic presentation. Thank you so much. Tom and Rowena, I thought I might ask you a question as the authors of the report. Was there anything that really surprised you when you were doing the research that went behind this report? It's a fantastic piece of work. I was just wondering if anything really jumped out at you through the process, surprise that you maybe had to do a little bit more thinking and research on.
For me, Mark, it was the fragility of what people think is a concrete right. So that was the first thing. The other thing was possibly the overexpansive. Well, people sometimes think that the right to protest is a superpower that lets them do anything, but it is circumscribed. And so trying to facilitate a good understanding of what the right to protest is and isn't in New South Wales was one of my key objectives. And then that leads to a discussion of, well, if that's the situation in New South Wales, what's the situation in other jurisdictions? And it's always in the public interest to compare jurisdictions and see if New South Wales laws are the best they can be. So that was my sort of approach. I don't know, Rowena, did you want to add?
I guess I was surprised at how many different systems operate across Australia. It was a really stark reminder that we are a federation of states, and states have gone down different paths for different reasons. Simon mentioned before the slightly alternative model of Queensland, and some of that, or a lot of that, was a reaction, I think, from the previous eras, shall we say, a Bjelke-Petersen era and so on, Fitzgerald inquiry in Queensland. An interesting thing I didn't realise, I think Victoria and Northern Territory are the only jurisdictions where you apply to the local council in the area that you would like to hold a protest rather than specifically going through the police. And interestingly, that sort of backfired in Victoria because there were a few incidents there around the like 2016, where there were awkward situations arose where the police weren't informed or aware. And so they amended the Act to say that the council had to actually confer with the police. So I think an involvement of the police, even if that's not where protesters initially go, the police, it could be argued, need to be aware of what's going on because of their duties. So even in Victoria, where you apply to the local council, the police have to be consulted by the local council. So I didn't know that, and it's really interesting to see the pathways that the different jurisdictions have gone down and why that has been a factor for that particular area and the history that's influenced that.
I might just add to that before we get to next questions, whether there was anything, Simon, that surprised you about, you've now read the paper. Was there anything that was like, oh, didn't know that?
I didn't know about the Queensland. I didn't know about the Queensland jurisdiction, and I agree with you. It's a very powerful contrast. So that really struck me.
Yeah, that's good. Okay, other questions? Yeah, up the back.
Before I was an MP, when I had a real job, and I worked as a lawyer. I'm joking. I really am being facetious. Really, I love my job. But worked in local court jurisdictions representing protesters a lot. I'm curious why, perhaps in the report, and I may be wrong, that I didn't see a reference to the police powers, responsibilities, legislation, and the limitation on the exercise of police discretion in relation to the apparently genuine demonstration or protest. You made great reference to it in relation to the issuing of a penalty infringement notice. And I know that the professor was referring to how much is police discretion, and it absolutely is. And this is a provision that, as lawyers practicing, we've used that quite a lot to get rid of charges that should never have been laid. And just curious about whether that came up in your research.
Yes, so we talked about the police powers in that chapter there, and sorry, what was the?
It was just provision 200 of the LEPRA refers to that limitation on the exercise of police powers to charge or issue move-ons, which is a particular tool the police use, and we saw that further limitation. The limitation on the police's powers limitation in that tranche of anti-protest laws we saw in the early term of the former government.
Yep, I think that might be in the footnote actually. So it may not be as prominent as it could be. So, but there are because we discussed the infringement notice is referred to as an equivalent of the other limitation. I can find it shortly and refer to it, but I agree, it is an important limitation. Yes.
We can also come back to you on that, on notice. Yeah, thank you. Other questions? Yeah, Christy at the back.
I'm just interested in talking about the discretion that the police and the courts have in making these decisions. What are the constraints? What other kind of constraints? I assume that they can't just do anything that they want, but they're constrained by case law or other kinds of considerations, and I'm wondering what those are and what sort of effects they have.
I don't know if this is who is best to answer. Maybe Simon, you start.
No, I think Tom and Marina have looked into it in more detail. There is the Supreme Court has interesting and fairly consistent jurisprudence. There was this rush of it. So from BLM through COVID, there's been quite an intense series of single judge decisions in the Supreme Court, and they've been largely consistent and building on each other. So yeah, they've developed some degree of precedent value in the criteria that Tom and Rowena have summarised in the paper, those sort of considerations. So they're there as they have a little checklist of things that they weigh up, but there's some starkly different results they arrive at.
I don't really have anything to add to that, so just ask if there's any further questions.
Okay. Any further questions? Julie. Yeah.
Thank you. That was a really terrific paper. I just wondered whether in any jurisdiction you're aware of where the police, or if in the case of the councils, is there any transparency in terms of reporting on protests that are approved or not approved? Is there any data of that kind that you discovered over your research?
What we found was court cases, Supreme Court cases, but not decisions made by the Commissioner of Police about which notifications to authorise. So yeah, at the moment that's unknown.
It's not unknown, is it?
Yes.
So do you want to just say that into the mic? Sorry, so
I just said presumably it's not unknowable. You could GIPR it if you wanted to, and I've never seen that done. Yeah.
I think in the paper we cite the author Geoffrey Gordon a few times, and he mentions in one of his articles that data was not publicly available on the number of protester applications or notifications to the police, that it's not a publicly available thing. But yeah, if you wanted to put in a GIPR request, you see how you go with that. So with our research, mainly we were looking at cases that did get to court because either the police were seeking a prohibition order or the protester was seeking an authorisation order, and then through the case they would, refer to the notification process, and you glean a certain amount of information about how these applications, how frequent they were. Well, they seemed to be quite a few during COVID, put it that way, but you would glean those sort of details through the cases. But in terms of systematic data, no, we didn't find any.
And we don't do GIPR requests as part of our work, yeah.
No.
I do. Yeah. Just lest you get the wrong impression, lots of protests happen without authorisation. That very gentle protest happening across the road right now, if the people have a yellow banner up Wilderness, I'd be surprised if they had authorisation for that. They're exercising their common law right. They're standing in the corner, they're not getting in anyone's way. The police will authorise lots of protests that are completely unremarkable. It's only when the protests threaten to be big and disruptive and at the wrong time, like sitting on the Story Bridge, that they'll end up, one party or the other will end up in the Supreme Court. So it's a good point. We're not seeing how much is going on, but anecdotally, lots of protests happen, one with police authorisation unremarkably, and lots without even bothering with police authorisation because they're not causing anybody any huge difficulty. I mean, it's a whole discussion about kind of protest and what you want to achieve. Does a protest have to be disruptive? Not at all. I mean, you can sit quiet on a park bench with a poster up, and that's a protest, or you can lie down on the road. So there's a wide spectrum in the police discretion, and the approvals will follow that spectrum.
I was just going to add very quickly that the term authorisation order, just to emphasise a point, can imply that if you don't have an authorisation order, the protest is illegal, whereas in effect it's just the exercise, it's the exercise of the common law freedom of assembly. So without protection, but it is the exercise of that right. And likewise, as we say in the paper, a prohibition order prohibits nothing. So in a sense that if there's a prohibition order, it doesn't take away the right to exercise the freedom of assembly. What it effectively is a decision of the court not to provide the limited protection under the Summary Offences Act.
Okay, we have the 2:15 bells, which is a great closing point. Join me in thanking Simon, Tom and Rowena. a really great session, a really fabulous paper. Thank you, Simon, for joining us. We really appreciate it. And yeah, thank you very much. And have a good day, people.